So in this video I want to talk about foreign divorces in Ireland, the recognition of foreign divorces in Ireland. There's two pieces of legislation that govern this whole area. One is the Domicile and Recognition of Foreign Divorces Act 1986. It's a short piece of legislation. There's only 6 sections in it, and the relevant or most important one is section 5. I'll deal with that just in a minute. The other significant piece of legislation is the Brussels II regulation of 2001, which was later amended by Brussels II bis, it's called. It's essentially regulations from Brussels to do with the recognition of divorces across the EU, in the EU area. So that was the whole purpose of that legislation, or those regulations rather. And the Domicile and Recognition of Foreign Divorces Act of 1986 is the principal piece of legislation in Ireland in relation to the recognition of foreign divorces. And the key section is, as I say, section 5. It says that a divorce shall be recognised in Ireland if granted in the country where either spouse is domiciled. So if either spouse is domiciled in a foreign country, foreign from Ireland, and a divorce is granted, then that divorce will be recognised in Ireland, provided one of the parties was domiciled in that country at the time of the granting of the divorce. And where a country has 2 or more systems applying in different territorial units, two systems of divorce as it were, then it will have the effect that each territorial unit will be treated as a separate country. In relation then to England and Wales and Scotland and Northern Ireland and the Isle of Man and the Channel Islands, all of these will be lumped in together, quite frankly, which basically means that a divorce granted in either of those or any of those countries will be recognised in Ireland, as if it was one country, as if England and Wales or Scotland and Northern Ireland or the Isle of Man or the Channel Islands were one country. So a divorce granted in any of those jurisdictions shall be recognised if either spouse is domiciled in any of those jurisdictions. That's the story in relation to UK divorces. In order to have recognition brought about then, given legal effect in Ireland, you look at the Family Law Act of 1995, you use section 29 and you bring an application to the Circuit Court or High Court to have a declaration or to seek a declaration that the foreign divorce is entitled to be recognised in Ireland. That Act, that Family Law Act of 1995, section 29, also makes provision for various other declarations that you might seek in relation to divorce or legal separations or annulments or anything else which would be granted in foreign courts. In relation to United States divorces then, generally each state or jurisdiction is treated separately for the purposes of recognition of a foreign divorce in Ireland, and that's obviously very relevant to the United States, where you've got 50 states. UK divorces then, slightly different situation. The UK is considered to be one state, as I said, so the effect of this is that a divorce granted anywhere in the UK will be recognised in Ireland, provided that one of the spouses is domiciled anywhere in the UK when the divorce is granted. Exceptions to the recognition of foreign divorces then in Ireland will come about in relation to non-judicial divorces. Generally, divorce will have to be obtained legally or judicially in the foreign jurisdiction. Sometimes you'll have a divorce which will be granted in some sort of a religious ceremony. That may not be sufficient for recognition here. So non-judicial divorces will be one of the exceptions to the recognition of foreign divorces in Ireland. Also, duress. If a spouse is pressurised or put under duress to apply for a divorce, the subsequent divorce will not be recognised in Ireland. Another exception, the third one, is fraud. If a foreign divorce is obtained by fraud, it will not be recognised in Ireland as a valid divorce. And there's a general catch-all sort of fourth category, denial of justice. This is a wide catch-all type of category which affords considerable discretion to the Irish courts in recognising or not recognising foreign divorces. So if it believes that there's some perversion of justice or that justice will be denied, then it can refuse to recognise a foreign divorce. That's really it. The Brussels II regulations, then the European Council regulations, granted or provided for the recognition of divorces, separations and nullities granted in other EU jurisdictions. And the whole purpose of Brussels II bis regulations would be that you apply where one of the spouses resides in or is a national of another EU member state, and the principal aim of the regulations is to recognise EU divorces on an EU-wide basis. So that is that really. I hope you find this video useful. As I say, the two key pieces of legislation are the Domicile and Recognition of Foreign Divorces Act 1986 and the Brussels II regulations. And the key thing is that where one of the parties is domiciled in a particular jurisdiction and that jurisdiction grants a divorce, well, in that case, that divorce generally will be recognised in Ireland, and the relevant act then that you use to bring your application to the Circuit Court or High Court here is the Family Law Act 1995 section 29. Hope you find this video useful. If you do, I'd appreciate if you would give it the thumbs up down below. Thanks for watching.